Good morning, this is your Kelso Report for Thursday, June 28th, and I'm your host, Clark Kelso. We begin with the Ninth Circuit on a case involving venue in a criminal case. The defendant in United States v. Gonzalez received 2 telephone calls from a government informant. The informant was located in the Northern District of California. The defendant was outside the Northern District at the time, and the calls involved a drug sale that was to be completed in the Eastern District of California. The question for the Ninth Circuit was whether venue was proper in the Northern District. Now, the United States Constitution and federal law require that crimes be prosecuted where the offense was committed. But determining where an offense occurred can be quite tricky, particularly for continuing crimes like conspiracy, where the conspirator's activities often have a ripple-like effect that may involve numerous districts. In the view of the Ninth Circuit in this case, the 2 phone calls had the consequence of propelling the conspiracy into the Northern District, so venue was proper in that district. Now, don't feel sorry for the defendant who was not in the Northern District. If trial in the Northern District would have been inconvenient or unduly burdensome, the defendant always has the option to make a motion to transfer to another district, a motion the defendant did not make in this case. Next, we have a standing holding in civil procedure. The plaintiff in Brownstein v. Arizona Department of Transportation contacted several general contractors who were bidding on a state construction project. But the plaintiff did not actually submit a quote or bid to any of those potential prime contractors. He just called them up and said, "Hey, I'm here." Nevertheless, the plaintiff filed an action in federal court seeking damages against the government based on the allegation that Arizona's affirmative action in public contracting program violated the plaintiff's rights to equal protection. Well, the Ninth Circuit held that the plaintiff had failed to allege an injury in fact, and therefore lacked Article III standing. Now, I'm sure we all remember that to satisfy Article III standing, a plaintiff must show he has suffered an injury in fact that is concrete and particularized, not conjectural or hypothetical. You have to show the injury is fairly traceable to the challenged action of the defendant, and you have to show it's likely, as opposed to merely speculative, that the injury will be redressed by a favorable decision. Well, given that the plaintiff hadn't even submitted formal quotes or bids for business, pretty much everything about his potential injury was made up and speculative. Ninth Circuit held there was no injury in fact, therefore no Article III standing. Our next case involves immigration. The Board of Immigration Appeals governing regulations limit the board's scope of review of an immigration judge's factual findings so that the board may only review findings of fact for clear error. The board is prohibited from making its own factual determinations. In Rodriguez v. Holder, the Ninth Circuit reversed the board's judgment, reversing an immigration judge's determination that the petitioner was admissible because the board exceeded its limited review jurisdiction and improperly engaged in de novo fact-finding. The Ninth Circuit panel remanded so the board could properly review the immigration judge's determination without the de novo fact-finding. Next, we turn to a state law case involving the doctrine of waste. Following a foreclosure sale under a deed of trust securing a purchase money note, where there is still a deficiency remaining, an action for waste against the former owner may be filed if there is a showing of bad faith waste, which is defined as any waste that is not committed as a result of the economic pressures of a market downturn. In Fate versus New Phase Development, the 3rd District faced a situation where the former owner had demolished a building on the property in preparation for new development. But the economic downturn not only stopped the new development, but also led to the former owner defaulting on the promissory note. Applying the definition of bad faith waste that I previously gave, the 3rd District concluded that the note holder could indeed sue for waste, since the destruction of the building on the property was not a result of the economic pressures of the market downturn. It was actually an attempt to develop the property. As the court noted, the impairment of security that results from the destruction of a building is actionable waste, notwithstanding the anti-deficiency statutes, unless the destruction itself was somehow caused by the economic pressures of a depressed market. Good news for the note holder in that case. Next, we have a case involving franchisor vicarious liability. In Patterson versus Domino's Pizza, an employee of a Domino's franchise sued both the local store and Domino's Pizza for an alleged assault and sexual harassment by the assistant manager of the restaurant. The Superior Court granted summary judgment to Domino's Pizza on the ground that the franchise was an independent contractor, and Domino's Pizza, therefore, could not be held liable on a vicarious liability theory. The law is well settled that the vicarious liability of a franchisor to a franchisee's employee depends on the nature of the franchise relationship. If the franchisee is an independent contractor, vicarious liability does not apply. But if the franchisee is an agent, well, then the principal can be held liable. Now, as I'm sure you remember, the difference between an agent and an independent contractor has to do with the degree of control over the means and manner in which the work is done. The general rule is that where a franchise agreement gives the franchisor the right to complete or substantial control over the franchisee, an agency relationship exists, even where the franchise agreement states that the franchisee is an independent contractor. On the record in this case, it was clear that Domino's exercised detailed control over employees' overall look, their demeanor, their training, their discipline, among other things. This factual record was easily sufficient to withstand Domino's motion for summary judgment, and the 2nd District reversed and remanded for further proceedings. And it looks like Domino's may be on the hook for the sexual harassment. Finally, we have a case involving the law of aiding and abetting. In People v. Loza, the 4th District concluded that the defendant's counsel should have objected to the trial court's use of the equally guilty language in Cal Crim number 400, which deals with aiding and abetting liability. And counsel should also have objected to the court's proposed response to the jury's questions with respect to its consideration of the aider and abettor's intent. Now, the law is clear that an aider and abettor may have a state of mind different from the perpetrators, and the defendant's state of mind was a crucial issue in this particular case. Counsel's failure to ensure that the jury was properly informed that it was required to determine the intent of an aider and abettor separately from that of the perpetrator, they're not equally guilty, that cannot reasonably be deemed to have been a tactical error by counsel, and the court therefore concluded it constituted ineffective assistance of counsel. As a result, the judgment of conviction for first-degree murder against the aiding and abetting defendant was reversed, because there was a reasonable probability the outcome would have been different but for counsel's error in failing to object to the erroneous jury instruction. And that's it for today's Kelso Report. Have a great day in the law.